Hi, I'm David Slonim of the Slonim Law Firm, and I'm here with my co-attorney, Kathleen Good, and we're here to talk a little bit about what we're finding is of interest to us and also our clients these days in respect to what we do. And at the Slonim Law Firm, we handle a variety of elder law issues that cover everything from estate planning, which includes the wills, trusts, advance directives, and also probate matters, guardianship matters, and government benefits such as Medicaid planning for clients as well. So we are here usually every Thursday, and many of our clients also see us in the directory that is present for everybody to find us on as well. So I'd like to introduce again Kathleen Good, who's here on the screen now, and she's an attorney that's based out of Clearwater for us, but she also handles matters here in Kissimmee and even in Melbourne remotely through the magic of our technology. So Kathleen, how long have you enjoyed estate planning with us here?
Let's see, with you, I've only enjoyed estate planning for approximately 6 months.
6 months?
Yeah,
okay.
Probably around there, yeah.
So, yeah, it's been a fun ride so far.
It has been. I've learned a lot from you, yes. You want to talk about estate planning and why it's important?
Yeah, so I've been here in Good Sam for I think 6-7 years now, and have enjoyed a wide variety of clients discussing some estate planning needs. And what we find is generally some curiosity regarding what estate planning does and how things interact with one another. Why a will is needed. What is probate? Is it one document? If you have a will, do you need to have a probate? And so these are all things that we can share with you today, and some of our myths and misconceptions that we come across as well, and help clarify some of those. You can always call my office to schedule an appointment with us, and we can have some more discussions about that, about your personal needs as we go along. So when we do a will, for example, what we find is that clients misunderstand what a will does. And so just as a refresher for anybody that may know, then a will or last will and testament is the way I like to consider it an instruction manual for probate. Basically, it just tells the court how you want to have things distributed. If there is no will, then the courts are going to go and distribute assets based on the Florida statute. And so what we do with a will is basically have your last testaments or interests kind of laid out for people to be able to follow. And in the will, there's a person named a personal representative, and that personal representative is the person who is going to actually act on your directives based on that last will and testament, right?
Most definitely. And talk about a little bit about when is probate going to happen? I get that question a lot.
Sure.
Well, is it always probated?
No, yeah. So it depends on the assets that a person has. And so when you have beneficiary designations on an account, then that isn't going to go through probate. So anything that has a beneficiary on it, so it's whether or not it's a bank account, a checking, savings, money market account, CD, or retirement accounts like IRAs, 401ks, all of those sorts of things, brokerage accounts, those don't go through probate if there's beneficiary designations. But some of those things may, if there aren't beneficiary designations on there, and then that could cause us to have to go through the whole court process.
Or anything that is not titled in their name alone wouldn't be probated, but if it's in their name alone, needs retitled, that's the purpose of probate.
Right. Yes. And so, even if you have a mobile home here or a vehicle, those things may or may not have to go through the probate process depending on how it's titled. And sometimes the personal representative has to go through a few hoops to handle some of that there. But that's something that we can certainly explore a little bit more if necessary there. But probate process, how long does it take usually, your experience so far?
It depends on the situation. 6 to 9 months could be a quick one, right? If there's a summary, or it could take up to 2 years.
Some could take a while.
Yeah.
Right. So
depending on
in
the
Florida,
assets.
you know, there's several different kinds of probate administrations. One is a summary administration, and that's usually for assets that are under 2 years or $75,000 or less. If there are excess assets than that, then we would have to do what's called a formal administration, and that actually names a personal representative. And that formal administration is the one that takes a little longer, but there are some actual benefits to doing a formal administration if that time were to come. So let's say you haven't passed away yet, but you're incapacitated, then there's other documents that we do as well. And so what are the advance directives that you've helped clients with?
I think they always wonder if they need the advance directives. And I try to let them know that they're the living documents they use while they're alive. So these are the documents that will not be active anymore once they do pass away. And that's when the will becomes active, or the trust. So we have your advance directives. We have living will. When is that important?
So the living will is basically, I like to think of it when the last hours or days of your life, you're telling your family and your doctors what you want to have done or not done as far as life prolonging procedures. And so that's really important, I think, especially these days when people talk about do not resuscitate orders and other situations like that, then those living will documents are really important. Now, that doesn't necessarily mean that that's exactly what's going to happen, but it's your directive as to how things would happen there. And if you don't have that, then there's nothing that says what's going to happen, right?
And it's a lot of strain on your family.
Yes.
It really helps your family make the decisions. So they don't have to make the decisions, I should say.
Yeah, taking that burden off is a great benefit.
That's the purpose of it. It's not an easy document to do, but it's very important.
No, I think when we do our estate planning, that document on its own is probably the most challenging document for our clients to come to terms with, because we are thinking about our own mortality in a very distinct way. So
and they think it comes into play just every time they go to the hospital or have a broken leg, and it doesn't. It's only if 2 doctors have agreed that there's really not much that can be done. You are dying. Right.
So it's just at the last hours or days. It's not just if a person has a stroke or broke a leg or something else like that. It's really just further down the line a little bit there.
Right, and that ties into the healthcare surrogate, which is the other living document. It's just who you want to represent. Make your decisions for you, so you can nominate who you want that to be. Power of attorney, why is that important?
Oh boy.
In so many ways, in so many areas.
So Florida is really strict about these documents in that if you don't have a power of attorney and you don't have a healthcare surrogate and you're incapacitated, and if somebody's exploiting you or there's some inability to handle your own affairs, then the only alternative to these documents then is to have a guardianship. And we'll talk about a prenatal guardianship in a little bit, but if there's no power of attorney and no healthcare surrogate, then somebody's going to have to go to court to actually take over your rights and powers with respect to your legal, financial, and medical matters. And that is really money consuming. I mean, it's no less than about $10,000 that you're going to pay, essentially. And then it's time consuming and emotionally consuming. So there's a lot of good reasons to have that power of attorney and the healthcare surrogate in place. And so in Florida, the power of attorney is only good within the 4 corners of the document, right? So what does that mean?
As with any contract.
Right. Yeah. So what does the 4 corners kind of?
Within the 4, I'm surprised you brought that up. Within the 4 corners, if it's not in the document, then they're not going to assume that it's in the document. So basically, it's an encompassing document. It covers so much in Florida, and it's a very broad power or power of attorney. So
Yeah.
everything's in the four corners. Let's put it that way.
Right. And so many of the clients, at least in Good Sam, have come from other places. Let's call them other corners of the country. So when that happens, then we have a look at the previous document. And technically, under the U.S. Constitution, that former document is given the full faith and credit to say that it's still valid. But the problem is that Florida law is a little different when it comes to the actual use of that document.
Yeah.
And so the banks and other financial institutions and even medical providers prefer to have a local Florida document in place. And so and it is restrictive in that it has to be, as Kathleen said, within the four corners, right? So I've had banks refuse to allow a son to act on dad's behalf because the other document didn't specifically mention individual retirement accounts.
Right.
And our power of attorney has that language in there that allows for that to happen. So the banks are real picky about some of that.
And there's even selections in our power of
Right.
attorney because
Right.
Florida law, certain ones, what we call superpowers.
Yeah, I like to call them
that they're spelled out.
superpowers.
Yeah, they are spelled out, so you can choose or not choose to have these powers given to your.
Yeah.
Yeah.
Yeah, and one thing that's really important about the power of attorney that a lot of people don't recognize is that as soon as you sign it, it's effective, which is different from the healthcare surrogate.
Right. And in some states too.
Right.
Yeah.
Right. So
But now
yeah.
it's durable. It
So-
starts immediately.
Yeah, it right away. And so as soon as you sign that document, then it is effective. And so that means that the person that you name as your agent during that durable power of attorney phase is able to act. Even if you have capacity, then they're able to act on your behalf. So kind of a two-sided sword. If you're out of the country and something needs to get done, then it can get done. But you always have to be cautious about who you name in the document because if you really don't feel you have trust in them that they're going to have your best interest at heart, we may want to think about who's going to be on there.
Yeah, it's very important.
Yeah.
On that topic, healthcare surrogate, which is we had mentioned, I want you to talk about, because you have told me before, why that is so important and what has happened to couples if they don't have a healthcare surrogate, including their spouse, which has happened in hospitals.
Yeah,
Tell
yeah.
the story. You've had clients which surprised me, but go ahead.
So a couple things. If you don't have a healthcare surrogate, then the Florida statute allows for a healthcare proxy. But the healthcare proxy statute doesn't have the spouse as the top person on the list. Your guardian is actually first, and the spouse comes next, and then children, etc. But the problem is that if you don't have a document like that, the hospitals will sometimes not even allow you to come into the room or not make medical decisions for your spouse. Yeah,
Which
yeah.
is my
and
point.
so, I mean that healthcare proxy is okay, but the healthcare surrogate is what really needs to
really
be done.
important. Yeah.
And I've had some husbands and wives have some significant issues just because those documents weren't done.
And I've had them tell me, oh, I don't really need that document because I would be for my husband anyway. And I'm like, not necessarily.
Right. Just
better to be safe. It depends on the institution.
just being a spouse is not good enough. You've
so
got
these
to have
documents protect your wishes and protect you. Yeah.
Right.
So that's the whole point of it.
And I like to call all the advanced directives kind of life planning, right? Because some people come to me, and I've had this kind of one of the myths and misconceptions that I like to cover is that when we're doing this, it's not just estate planning. Not everybody necessarily has an estate, right? But everybody's got a life. And so we're doing life planning, and most of the documents, all those advanced directives, the power of attorney, the healthcare surrogate, the living will, the prenatal guardian declaration, even the trust, are all about what happens while you're alive, but maybe incapacitated. Only the will, which is the one out of the 6 documents, actually deals with your death. So,
that's a good point.
When we talk about this with clients, it's really more about what's happening while you're alive, but maybe incapacitated. And this creates a much better scenario for people as they're going through life.
It's life planning.
It is life
It's
planning.
not just for death, yeah.
In fact, just prior to our interview here, I was on the phone with a client. We were discussing one other matter that he had that he was taking care of his mom about. But as he's talking to me, he says, well, I can't talk long because my wife just had a stroke. And so he had to get off the phone and do other things relating to that. And so, that was a situation where entirely unexpected.
Yeah.
And it's important to have the documents already done, so that way you can go into the hospital, do whatever needs to get done, and we're not having to be in a crisis situation.
You don't want to do it in a crisis, and often you can't.
Oftentimes, yeah, because when you're having a stroke, obviously you're not capacitated, you can't sign anything, and so then we, have some significant problems there. In fact, tomorrow, I'm going to visit a client at their home. The husband is on hospice and in the home, and we're getting documents signed even then because the husband and the wife don't want to have additional complications or other issues that are going to come up in short order. So yeah, these sorts of things happen all the time.
Very important to plan for these.
Right, yeah. And so when we deal with the parents and they're talking about their kids, do you come across situations sometimes when they're worried about what's going to happen and they don't want to do probate, but they don't know if they want to put their kids on a bank account or some other thing like that, or even a house? They're wondering whether or not they want to put their kids on that.
Right.
And would you agree that we would find as a myth or misconception that they have that putting their kids on the account is a good idea? And I think, go ahead.
Well, I often say, once your name is on the account, it's a good idea not to be alone on the account. It's a good idea if you have a joint account with your husband, for example. But the beneficiaries are what's key. So payable on death or transfer on death if it's an investment account. But the point being, they'll add their children ahead of time, just like they might on a deed or things like that. And then I try to go through the process of each asset and show them what would happen as they pass away. In this scenario, what could happen while they're still alive. And so I make sure that what their wishes are, and then I proceed. Like if you want your child to inherit this once you pass away, it's not necessary to put them on the account now. That's why beneficiaries are important. Deeds are the same way. It depends on the type of asset, but you're looking at it from the standpoint moving forward, not right now. So that's kind of where.
And there's some potential liability or cautions that I generally point out. If a parent puts their child as a joint account owner, then we've got a problem potentially if that child goes through a divorce or has some other creditor situation.
Or predeceases you.
Yeah.
Same creditor situation.
Right. Yeah. And so then that account, there's no bright line in that account that says, okay, this is mine or this is my child's, and it's all there. And so it's always important to not have the child on the bank account if you can help it. And then we can use the power of attorney as that firewall. And that would allow then the child or other person you name to be able to write checks for you if you can't do it yourself, or to do other things. And then with a beneficiary designation on that account, then it's going to go right to the beneficiaries, and then we don't have to worry about creditors, we don't have to worry about some of these other scenarios. And it makes a nice clean package, so to speak. So I generally prefer that idea. The same for real property. So if there's a condo or a house or something else like that, then we don't want to have that, the other person on there. So that's something that we do come across a lot, and it's generally people like to do that, and I don't.
It's difficult to change.
It is, especially on a deed, because then you've got to take the kid's name off, and sometimes parents have done this ahead of time, and then there's some sort of break up between the parents and the kids, and the kids don't want, and the family doesn't want to sign, and so then we have all sorts of a mess. I know you're dealing with a situation.
Or they want to sell,
now with that mom, and there's 3 kids in New York, and they're all estranged, and they don't want to sign, and it's a real mess there. So you always have to watch out ahead of time. These are big decisions that I think are important to talk to an attorney about ahead of time. And then you can get some good advice and kind of follow that advice, I hope. Yeah. Yeah.
Like, follow it.
So, so let's say that we have a situation where you don't have these documents, and then something happens to you, and there's some exploitation. And I've had a situation recently with a gentleman in Kissimmee, and he unfortunately didn't have any family. He didn't have any kids. His wife had passed away, and he had a neighbor that offered to be his agent through the power of attorney. And then we found out through a family friend who became very concerned that this agent, who, you know, the neighbor guy, started stealing essentially hundreds of thousands of dollars from this guy. And, you know, then we had to institute through a professional guardian a guardianship.
That's the importance of guardianship.
Oh, yeah.
A lot of people don't really know what that is.
And so guardianship is a great point. So guardianship is basically where it is the most restrictive means of taking a person's rights away for care purposes, usually. It's usually if there's some incapacity and there's no legal documents that are in place, no power of attorney, no healthcare surrogate.
Avoid potential guardianship if you
Yeah.
have these documents in place already. But
Yeah, right. I mean, a couple $100 for these documents sounds like a lot when you're doing them, but it's a lot less than thousands of dollars for a guardianship. And so, you know, that's really important to kind of keep that in mind. And then the guardianship proceeding takes a while. We've got to go through potentially an emergency temporary hearing, which basically places the guardianship in place for about 90 days. And then we have a plenary or final hearing at the very end, which is going to kind of get all that formalized. And so there's a lot of attorneys involved. There's, you know, medical personnel involved, and it can become and there's court. And you know, not everybody goes to court on a weekly basis like we do. So, you know, it's not a second home for them, right? So if you want to avoid that, usually those advance directives are helpful. Sometimes, unfortunately, that guardianship is required, and so you have to know that that guardianship is something that has to go through the court system to be done, right? And there is an advance directive called a pre-need guardianship declaration. And that advance directive basically tells the court ahead of time who you would want to have as your guardian. And that can be helpful, and I've actually used that in some situations in court where that advance directive was the only thing keeping us from a bad guardian, potentially. Because
or
anybody...
the court appointing.
Or court appointing.
Just appointing
because anybody could file for a guardianship. You know, I've had situations where a neighbor or a creditor wants to file for potentially bad reasons. And so then we were able to use, in one case, that pre-need guardianship declaration to name the right person. And so that was helpful as well. And finally, I just wanted to briefly touch on government benefits and Medicaid. And you know, usually a lot of people think Medicaid is not for them, right?
Oh, of course. I'm learning from you right now on Medicaid. So I thought it was only for people that didn't make a certain amount or didn't,
Right.
It's not that case at all.
It's not. And you know, we've helped clients with hundreds of thousands of dollars, and they just don't want to have to go into a nursing home and
nursing
spend.
Homes are expensive.
Right. I mean, we're seeing bills of over $10,000 a month for that care, and that doesn't include medications or other things like that. That's just room and board.
And you could have a nice savings to be in your retirement, and that could be
gone. Right.
And that's what I'm learning. Like Medicaid is a very important asset to have.
Yeah, so Medicaid is something that we assist with as far as the application goes, where we can reallocate certain assets to ensure that if your loved one is in a nursing home, then you're not going to be spending all of your hard-earned money going just to the nursing home.
Instead of your retirement.
Right. And so then we're able to get the state to help offset the costs of that expenditure, and then we're able to kind of help you kind of continue on, right?
So, and have your assets go where you might have wanted them to, like family. You have to deplete them, so your family won't get that.
Right, yeah.
It's very important.
Yeah, and so, you know, that, and then sometimes we can also even talk about trust, but maybe that'll be for another discussion. that we can have
Why do
there.
I need a trust? I get that question a lot.
Okay,
Or they want a trust. Yeah.
Yeah.
Why,
So
people come in preconceived. You can keep it simple. Like, what are some of the main reasons we would use a trust? Because it's not necessary for everyone.
It's not.
And they think it is. Sometimes.
So, right.
It's kind of, I mean, it's a good tool, but what are its purposes?
So yeah, so I'm gonna
Depending
just,
on the kind of trust.
you know,
But
think of why people used to want trust, right?
Yeah, yeah.
So used to want trust because their assets maybe were over the federal estate tax limit. In Florida, there's no state estate tax, but the federal estate tax used to be under $1 million, like
Right.
685,000 years ago. But now the federal estate tax for an individual is over $11 million, and for a couple, it's over $22.5 million, give or take. And so most people don't use a trust for trust or estate planning purposes anymore necessarily. But if they had assets, real estate specifically, outside of the state, then that is something that is useful for a trust, because we don't want to have to probate something in another state. We have the trustee being able to manage that. That does require transferring a deed of that property outside of Florida into the trust, but that's relatively easy to do. And then we also want to make sure that we have a distribution that is going over a periodic time. So some clients don't want all of their assets to go to their children or grandchildren in a lump sum. They may feel like one child doesn't have the financial aptitude to kind of spend the money appropriately, or they want something to go to a grandchild for college. And so a beneficiary designation or just something through a will devise does not have the ability to have a periodic distribution. It just basically goes one lump sum and you're done. And so
even if it's retirement accounts
even
or
right,
those
right.
types of accounts.
Yeah,
That's-
because even a retirement account can just go to a beneficiary, and then there's potentially the required minimum distribution or other thing, but it's all there available for them. And so a trust, depending on the kind of trust that it is, will then be able to have more of a granular or kind of specific distribution as you want it to be. It can be as complicated, it can be as simple as you want. And so that's sometimes some of the benefit of the trust, but really it's not for everybody anymore. Many people feel that they could just do a beneficiary designation or do something else, and there'll be no problem with that. But if they have very specific intent
like
to
probate avoidance.
probate
Perhaps
avoidance,
that might be one of the main purposes
sometimes, you know, if
sometimes,
it's or if they want to do planned gifting to organizations like Good Sam, for example, or other things like I've had one client who came in, they wanted to do like a annual distribution to the butterfly garden, or to, you know, transportation here, or do something else, and a trust is a great way to do that, and frankly the only way to be able to have that sort of ongoing distribution. Whereas again, a beneficiary designation or a will devise is just one time and you're done. So that's kind of the good reasons to have a trust, but we always now try to really dig down to see if a trust is as necessary as most people think it is. So good. So thank you for sharing the time with us today. Again, I'm David Slonim. This is Kathleen Good, and we are with the Slonim Law Firm. And again, just as a reminder, I am here usually most Thursdays, and you can always call my office, the number below, to schedule an appointment. We don't often take walk-ins, unfortunately, and we look forward to seeing you soon. Thanks very much.